Private law. 2.2.1 The law of persons. The law of persons is that part of private law which regulates the conception, the existence, and the termination of the natural person as a legal subject. The law of persons thus determines a. Who are legal subjects. How one becomes or ceases to be a legal subject. The various classes of legal subjects. What the legal position, status, of each of these various classes of legal subject is. It has already been indicated that every human being can be the bearer of rights and duties. Every human being is therefore a legal subject. At what stage does a human being become the bearer of rights and duties? In other words, when does the legal capacity, that is, the attribute of having rights and duties in the eyes of the law, of a human being come into existence? The answer to these questions appears to be that a human being and its legal capacity come into existence at birth. The rights of an unborn child are, however, also protected provided that the child is subsequently born alive. The legal capacity of a person is terminated by death. A deceased person can have neither rights nor duties. Nevertheless, the law protects the body as well as the deceased's former assets. However, the protection is not in the interests of the deceased. The body is protected in the interests of the community, and the deceased's former assets are protected in the interests of his or her creditors and heirs. Thus, in both cases protection is given to the interests of legal subjects, and not to the deceased, who is no longer a legal subject. Since legal subjects differ from one another, the law is also obliged to draw distinctions between them. For example, minors do not have the same rights as adults. To give recognition to these distinctions, status is accorded to every legal subject. Status is defined as the aggregate of rights and duties which are attached to a person as one of a specific class. Status is a legal condition. It is the position occupied by a legal subject in relation to his or her fellow legal subjects as a member of a particular class in the legal community. It is thus the position enjoyed by a person in the eyes of the law. It determines the extent of the rights and duties a legal subject may have. Status is conferred by the law. A person's status cannot be changed of his or her own accord, apart from the exceptional cases in which the law allows a change in status to follow on certain steps taken by the person, for example in the case of marriage. It should be noted, furthermore, that status can take various forms. A distinction is drawn between status in public law and in private law. The capacity to vote, for example, arises out of a person's public law status. All South African citizens over the age of 18 are entitled to vote. The capacity to acquire ownership is derived from private law status. There are numerous factors which determine the status of a legal subject, such as age, sex, marital status, and sanity. The law of persons is concerned specifically with the influence exerted by all these factors on the status of a legal subject. 2.2.2 Family law. The law of the family is that part of private law which has to do with the requirements for the conclusion of a valid marriage, the legal consequences of marriage, the grounds on which a marriage can be dissolved, and the legal relationship between parents and children. The law of the family has nothing to do with the relations between relatives, for example uncles and cousins or in-laws. It is concerned only with the two parties to a marriage, the law of husband and wife, and with the relationship between parents and children, the law of parental authority. The law of the family thus comprises two subdivisions, the law of husband and wife, and the law of parent and child. Page 28. 2.2.3 Law of personality. Persons have certain rights in respect of their physical being, their dignity, and their reputation. Thus, for example, everyone has a right not to be unlawfully assaulted. This right is protected by both criminal law, assault is a crime, and civil law, the assaulted person can sue the perpetrator for damages and delict. Similarly, everyone also has a right not to be insulted or defamed. The law of personality is concerned with the relations between people concerning their physical and psychical integrity. It ensures that each person has the undisturbed enjoyment of his or her personality property within the limits laid down by the legal order, and, under certain conditions, compels anyone who has infringed this right to pay a sum of money as compensation. From general experience, it is known that whoever says defamatory things about another, infringes the other's right to his or her reputation, may be compelled to pay a sum of money to the injured party. An important right of personality is the right of privacy. Every person is entitled to live a private life, and if another intrudes on his or her domestic sphere without permission, or displays a photograph of the person, the right to privacy is infringed. Here, an interesting and important question is, when may one do these things? Rights of personality, like all other rights, are subject to limitations. A politician, therefore, cannot complain if he or she is caricatured in a cartoon. 2.2.4 Patrimonial Law. Here, the relations involved are between persons as regards their patrimony. A person's patrimony consists of all his or her rights and duties which may be valued in money. It is, therefore, the sum of his or her assets and liabilities. 2.2.4.1 The Law of Property. The law of property is concerned with the relationships of persons towards material objects. The relationships of persons towards property are controlled by means of the granting and recognition of rights over property. The nature and extent of the legal power enjoyed by a person over property depend on the kind of real right held by that person. The different kinds of real rights confer different powers on their holders. The real right of ownership gives the holder of the right wide powers to use the property, to enjoy it, to destroy it, to sell it, and so forth. On the other hand, the more restricted right of pledge gives the holder of the right only the right to possess the property, which still belongs to the pledger, as security for his or her claim against the pledger. It is, of course, obvious that more than one real right can subsist in the same property. For example, Anna may have the right of ownership over a farm, and at the same time Becky may have a right of usufruct over the farm, Carol a mortgage over it, and Dolores mineral rights in respect of it. Accordingly, the holders of the various rights have certain powers over one and the same property, that is, the farm. The right of ownership is the cornerstone of all real rights and, at the same time, the most comprehensive right. The right of ownership is also extremely important as far as the law of property is concerned, and a few aspects of this right which have not yet been mentioned, such as the nature and acquisition of ownership, its protection, and the distinction between ownership and possession, will now be discussed. 2.2.4.1.1 The right of ownership. In principle, the right of ownership confers the most complete power over property. However, this in no way means that ownership confers unlimited or absolute control. An owner may not do what he or she likes with his or her property. The wide powers of the owner to use, enjoy, destroy, or sell the property, and so on, are restricted by the dictates of public law and the rights of others. Examples of public restriction are sanitary regulations, building regulations, statutory provisions which prohibit the division of land under certain circumstances, traffic rules which the motorist must obey, etc. This means, for instance, that the owner of a piece of land cannot build as he or she wishes, or that the motorist cannot drive as he or she likes. Ownership is always restricted in the interests of the community. An owner's rights may also be restricted by a neighbor's right of ownership. The owner of land, for example, may not excavate the land in such a way that a neighbor's land subsides or caves in. It should, therefore, be noted that although in theory the right of ownership confers comprehensive powers on its holder, it is nevertheless always restricted. 2.2.4.1.1.1 Ownership and possession. It is most important to distinguish clearly between ownership of property and possession of property. In everyday speech there is a tendency to use these two different concepts indiscriminately. For example, his possessions, she possesses a house, she is the possessor of a radio used to mean the property of which she is the owner, she is the owner of a house, or she has the ownership of a house, she is the owner of a radio. Ownership and possession are two quite different concepts in law. A person who has the right of ownership over property is not necessarily the possessor of the property. Abdul, the owner of a motor car, may, for example, lend it to Bambi for a trip to Durban. Abdul has ownership of the car, but Bambi is in possession of it. Or Kuz moves out of his house so that Gordon can repair it. Kuz is the owner of the house, but Gordon is the possessor. When is one actually in possession of property? At first glance, this seems a fairly simple question. It is, however, a difficult and disputed problem. For present purposes, it will be suffice it to say that possession has two elements, namely, the physical and the psychical. A person is in possession of property when he or she has physical control over it and, at the same time, has the required intention of possessing. The intention of possessing, that is, the physical attitude required by the law, is the intention of exercising physical control in one's own interests. In order to have physical control over property, direct and immediate control over it is not required. For example, if Abdul locks his car but takes the key with him, he has physical control over the car, although he may be kilometers away from it. A single example to illustrate the absence of the required intention to possess is the following. If MPO holds Ned's jacket for a few minutes while the latter works on her car, MPO has physical control over the jacket, but does not have the intention of possessing it, because she is not exercising the physical control in her own interests, but in the interests of Ned. In other words, she is not holding the jacket for herself, but for someone else. MPO is therefore not in possession of the jacket. 2.2.4.1.1.2 The acquisition of ownership. The way in which ownership is acquired is considered in this section. The basic distinction encountered in this respect is that between original and derivative methods of acquiring ownership. A. Original methods of acquiring ownership. Occupation. The most obvious and probably the oldest method of acquiring ownership is seizure or occupation. If one seizes property belonging to no one, with the intention of becoming its owner, one acquires the right of ownership over the property. For example, when Andrew catches a wild bird or a fish from the sea, or picks up a fountain pen someone else has thrown away, and keeps it for himself. Note, however, that one cannot by occupation become the owner of property belonging to another. If Sifo loses his fountain pen, he remains its owner, and Chipo will not be able to obtain ownership of the pen by occupation. However, if Sifo no longer has the intention of being the owner of the pen, he renounces his right of ownership. Chipo can acquire ownership by appropriation or seizure. Occupation is called an original method of acquiring ownership because the new owner does not obtain the right of ownership from another, but establishes an original right of ownership. Prescription. A person can become the owner of property by means of prescription if he or she has possessed it openly, as if he or she were its owner for an uninterrupted period of 30 years. For example, if Manla takes possession of a section of Baba's farm by allowing his cattle to graze on it, he may acquire ownership of that section, provided he has possessed it openly and as if he were the owner for an uninterrupted period of 30 years. Section 1 of the Prescription Act 68 of 1969. In this way, an act which was initially unlawful, appropriation of another's property without permission, leads to the acquisition of the right of ownership. The question is why the law allows an owner to lose his or her ownership in favor of another in these circumstances. The most important consideration is that of legal certainty. If an owner allows another to take possession of his or her property for a long period, the impression is created to the outside world that the possessor is actually the owner. The impression that the possessor has the right of ownership is upheld by the actual conferring of ownership on the possessor. Acquisition of ownership by prescription is an original method of acquiring ownership because the possessor does not obtain the previous owner's ownership, but establishes an original right of ownership after the original owner has lost ownership. B. Derivative methods of acquiring ownership. Movable property. The most commonly encountered method of acquiring ownership, however, is by delivery of property. This method is applicable only to movable property, that is, property which can be physically moved from one place to another, for example motor cars, books, or furniture. Immovables are land and everything permanently attached to it, such as houses, trees, or fences. For instance, if Lola and Fizil agree that Ola will buy Fizil's car, Fizil remains the owner of the car. Ola acquires ownership of the car only when Fizil delivers it to her, that is to say, puts her in control and possession of the car. Therefore, the mere entering into a contract of sale or donation does not cause the right of ownership over the property bought or donated to pass to the buyer or beneficiary. The seller or donor must first deliver the property to the buyer or beneficiary. However, it is not sufficient merely for physical transfer to take place. It must also be the intention of both the transferor and transferee that the right of ownership be transferred and acquired. If either party lacks this intention, ownership does not pass. For example, if Peter delivers a pen to Sam under the impression that he is lending it to Sam, and Sam receives the pen believing that Peter is giving it to him, it is clear that, while it is Sam's intention to obtain ownership, Peter certainly does not intend to transfer his right of ownership. Consequently, ownership does not pass to Sam. Delivery is a derivative method of acquiring the right of ownership, because the transferee obtains ownership from the transferor and does not establish an original right of ownership. Immovable property. Obviously, the right of ownership over immovable property cannot be acquired by means of delivery, because a farm or plot cannot be transferred physically. Instead of delivery, registration of the transfer at a deeds office is required. Thus, if Ivy buys Dora's farm, Ivy acquires ownership of the farm only when it is registered in her name, even though she may already have paid Dora the full purchase price. Registration is also a derivative method of acquiring ownership, because the seller transfers his or her right of ownership to the buyer. 2.2.4.1.1.3 The protection of ownership and of possession. Ownership is protected primarily by granting the owner the remedy known as the re vindicatio. With this action based on ownership, the owner may reclaim his or her property from any person who is wrongfully in possession of it. For instance, if David steals Brad's pen and sells it to Cecilia, who thinks David is the owner of the pen, Brad can reclaim the pen from Cecilia, in spite of Cecilia's good faith. The law thus accords particularly strong protection to the right of ownership. When someone damages or destroys property belonging to an owner, the owner can, in principle, claim damages from the perpetrator. Just as ownership is protected, so is possession protected. If Lindau borrows Ram's car and refuses to give the car back to Ram on his return, and Ram takes his car back by force or against Lindau's will, the court will protect Lindau's possession by ordering Ram, the owner, to restore possession to Lindau. If Lindau reclaims possession, Ram's contention that he is the owner of the car will be irrelevant. In an action in which someone asks that the possession he or she has lost be restored, the court is not interested in who the owner is, but only in the question whether the applicant was wrongfully deprived of possession. It is only when Ram has restored possession to Lindau that he, as owner, may claim the car from Lindau with an action based on ownership. He himself may not repossess the car against Lindau's will. This may sound strange, but there is a good reason for it. In order to prevent persons from using force in taking property claimed by them, mere possession of property is protected in the sense that no one, not even an owner, may deprive someone of possession against his or her will. The remedy with which possession is restored is called the mandament van spoli. 2.2.4.1.2 Servitudes. A right of servitude is a limited real right over the property of another, which confers on the holder of the right specific powers to use the property in a particular way. Servitudes are subdivided into predial servitudes and personal servitudes. A. Predial servitudes. The following are a few examples of predial servitudes. Podel, the owner of a plot, has the right to drive or walk over the plot of her neighbor. Sifo, the servitude of right-of-way. Mary has the right to fetch water from Nadia's plot. Servitude of drawing water. Zolo has the right to graze his cattle on Mark's farm. Servitude of grazing, and so on. In all these cases, the owner of a piece of land has certain powers in regard to the adjacent land belonging to another. The land of the owner who is the holder of the servitude is called the dominant tenement, and that of the owner who has to permit the exercise of the powers conferred by the servitude is called the servient tenement. Each subsequent owner of the dominant tenement may exercise the servitude, and each subsequent owner of the servient tenement has to permit the servitude to be exercised. The owner of the dominant tenement may demand that any person, including the owner of the servient tenement, who wrongfully obstructs the former in the exercise of his or her powers, cease such action. If the owner of the dominant tenement has suffered loss, he or she may also claim damages from the servient tenement. The most common method of acquiring a servitude is by registration of the servitude at a deeds office against the title deeds of the dominant and servient properties. The owners of the two properties normally agree on the granting of the servitude, which, however, only comes into being on registration. Like the right of ownership, servitudes can also be obtained by prescription. A person may acquire a servitude by prescription if he or she is openly, and as though he or she were entitled to do so, exercised for an uninterrupted period of 30 years the rights and powers which a person who has a right to such servitude is entitled to exercise. Section 6 of the Prescription Act 68 of 1969. B. Personal servitudes. Usufruct is the most important example of a personal servitude. In everyday speech it is often referred to as a life interest. A usufructuary has the power to use and enjoy the property of another. The usufructuary may take all the fruit and produce of the property. In the exercise of these powers, however, the property may not be destroyed or substantially altered. The usufructuary of a farm may not, for example, chop down trees without replacing them, because if this is done the substance of the property, the farm, would be altered. In practice, the rights enjoyed by the usufructuary are particularly valuable. The property may be cultivated for the usufructuary's own use, or it may be let. However, the usufruct may not be transferred to another, for example by selling it, because usufruct is regarded as being inseparably attached to the person of the usufructuary. Usufruct may be granted for any period of time, but for no longer than the lifetime of its holder. Usually it is granted for the lifetime of the usufructuary, hence the name life interest. The most important method by which a usufruct over immovable property is obtained is registration. Such registration usually takes place in terms of a testamentary disposition. For example, Tabo, a farmer, may provide in his will that his wife shall have a life interest, that is, a usufruct in his farm during her lifetime, and that his children shall receive the ownership of the farm. In this way he makes provision for his wife to enjoy the farm's yield during her lifetime, and for his children to enjoy the full, unlimited right of ownership after her death. 2.2.4.1.3 Mortgage and Pledge. Mortgage and pledge are limited real rights over property of which another has ownership. Mortgage and pledge both constitute ways in which debts can be secured. The object of mortgage is immovable property, and a mortgage is acquired by registration against the title deed. A pledge has, as its object, movable property, and is acquired through agreement and delivery of the property. For a discussion of security, see Chapter 23. 2.2.4.2 The Law of Succession. When a person dies, he or she leaves behind what is known as a deceased estate, which consists of all his or her assets and liabilities. This estate is administered by one or more executors under letters of executorship granted by the master. It is the duty of the executor to pay all the debts of the deceased, realizing the assets of the estate if necessary. After payment of all debts, the remaining balance must be distributed amongst the heirs or beneficiaries. The estate of a deceased vests in the executor, who consequently becomes the legal owner of the assets, but he or she has only bare dominium or naked ownership and not beneficial ownership, that is to say, no benefit accrues to the executor from this ownership. Conversely, the debts of the deceased are binding on the estate and not on the executor personally. Only the executor can sue and be sued in regard to estate matters. Since the executor is the legal representative of the deceased, legal proceedings are brought or defended by the executor in this capacity. As was stated above, the balance remaining after payment of the debts of the estate is distributed amongst the heirs or beneficiaries. Who these heirs or beneficiaries are depends on whether or not the deceased left a valid will. In the case of there being a valid will, the estate passes according to the rules of testate succession. If there is no valid will, the rules of intestate succession will apply. For a discussion of the law applying to the administration of deceased estates, see Chapter 29. 2.2.4.3 The Law of Intellectual Property. From ancient times there have always been things external to a person which are of value to him or her, but which are of an incorporeal, immaterial nature, for example, inventions and works of art. Since, in spite of their incorporeal and immaterial nature, these products of the human spirit may be of great economic value to their discoverer or creator, it very soon became necessary for the law to protect the bond between the creator and his or her creation. In other words, the law gave the creator of a new idea in the scientific, literary, or artistic sphere a right to his or her creation. In time, protection was extended, for example, to copyright, patents and trademarks. Today all products of the human intellect which are incorporeal and have economic value are regarded as incorporeal things in respect of which rights can exist. The most important rights in this respect are copyright, patents, trademarks, goodwill and models, that is, rights which relate to the products of a person's mind. In South Africa, the law relating to intellectual property is governed largely by legislation, for example by the Patents Act 57 of 1978, the Copyright Act 98 of 1978, the Trademarks Act 194 of 1993 and the Designs Act 195 of 1993. The law of intellectual property is discussed in Chapter 18. 2.2.4. For the law of obligations. When a personal right comes into existence between legal subjects, the bond or legal relationship between the legal subjects is referred to as an obligation. Personal rights may come about through contract, delict, or through various other causes of which the most important example is unjustified enrichment. The legal object in relation to a contract is the performance which must be delivered. In the case of a delict, it is the payment of compensation, and in the case of unjustified enrichment, the payment of an amount equal to an amount by which one person has been enriched to the detriment of another. The following serve as examples. If two parties conclude a contract, an obligation arises in terms of which one party has the right to demand that the other keep his or her promise, the other party thus has to render performance. Generally, both contracting parties are simultaneously obligee and obligor. For example, if Joan buys Steve's horse for R100, Joan has the right to claim the horse from Steve. Steve's performance is thus the delivery of the horse to Joan, but at the same time Joan is obliged to pay Steve the R100. Likewise, Steve is entitled to claim the R100 from Joan. Joan's performance is the payment of the R100, and at the same time Steve is bound to deliver the horse to Joan.
If, by committing a delict, Lindau causes damage to Vasi, for example, Lindau negligently drives her car into Vasi's fence, an obligation also arises between Lindau and Vasi. In terms of this obligation, Lindau is obliged to pay Vasi damages. This is the performance owing and Vasi has the right to claim damages. C. The last major source of obligation is unjustified enrichment. If Tobika pays Themba 500, believing erroneously that she owes the money to Themba, Themba is unjustly enriched at Tobika's expense. In terms of the obligation which arises, Tobika is entitled to claim the 500 from Themba who is obliged to repay it.
The general principles of the law of contract are discussed in greater detail in Section B, whereas in the following more attention is given to the law of delict and unjustified enrichment. 2.2.4.4.1 Introduction to the Law of Delict. This is probably one of the most interesting and all-pervading branches of the law. It is well known that everyone is to some degree or another exposed to the possibility of suffering damage or loss. The factors causing damage may be contained in natural disasters, such as lightning, hail, floodwaters or drought, or in human actions, such as negligent driving or defamatory statements. Compensation for damage suffered by a person can be recovered from another person only if there are legally recognized grounds for recovery. If, for example, a person has insured himself or herself against damage, the law will compel the insurer to make good such damage or loss. If, however, any damage is caused by the delict of another, that other person will be compelled by law to make good such damage or loss. The law of delict lays down what is required for an act causing damage to qualify as a delict and what remedies are available to the party suffering the damage. In order to determine the scope and bounds of a person's right of ownership to land, it must be determined what the legal norms allow a person to do with his or her land and what is forbidden to be done with such land. The law allows, for instance, a person to cultivate vegetables on his or her land, but not certain kinds of weeds, to build a house on it, but, in terms of a municipal regulation, a rule of the law, not less than 2 meters from the boundary, to make a fire on it, but not in such a way that the smoke is continually blowing into a neighbor's windows. At the same time, a neighbor's right to his or her land is similarly limited by legal norms which prescribe what may and may not be done with the land. If this were not so, there would be a continual clashing of interests. The law demarcates interests in the form of subjective rights and in this way ensures peaceful coexistence. Each of these rights has a fixed, limited content in accordance with the rules of the law. The content of a subjective right consists in the powers of the holder of the right. For instance, the owner of property has the power to enjoy, use, and alienate the property. The owner can walk on his or her land, lay out a garden or build a house, sell or let it. The content and scope of the owner's powers, and, therefore, the bounds of his or her right, vary in accordance with the provisions of the law which demarcate the owner's interests and those of other persons. Therefore, in a system of subjective rights regulated by objective law, the interests of the legal subjects are juridically demarcated. If one person's right is not respected by another, the retributive character of the legal order takes effect. The legal order comes to the aid of the prejudiced party with the power of the sword. This is done in 2 ways. The prejudiced party is granted an order, interdict, which forbids the other party to proceed with his or her course of action, or the wrongdoer is ordered to compensate the prejudiced party for the damage he or she has caused. 2.2.4.4.2 Definition of a delict. The mere fact that a person has caused another to suffer damage is insufficient to find delictual liability. Further requirements must be satisfied before delictual liability can follow. The different elements which constitute a delict appear from the following definition of this legal concept. A delict is any unlawful culpable act whereby a person, the wrongdoer, causes the other party, the person prejudiced, damage or an injury to personality, and whereby the prejudiced person is granted a right to damages or compensation, depending on the circumstances. From this definition, the following elements of a delict may be isolated: a. An act, b. Unlawfulness, c. Fault, d. Causation, and e. Damage or injury to personality, harm. To be held liable for the harm which he or she has caused another, the wrongdoer's action must comply with all these requirements or elements. An act. An act is any voluntary human conduct, but it need not be a willful act. In the first instance, this means that only a human being, not animals, for example, can act in the eyes of the law. Secondly, it means that any human conduct, either a commission or an omission, which at the time of the relevant activity was capable of being exercised under control of the will is, legally speaking, an act. Bearing this in mind, a gatekeeper who, while daydreaming, forgets to close the gate before an oncoming train, definitely acts, since his or her omission was capable of being controlled by will. On the other hand, the activities of a sleepwalker, or of a person who faints behind the steering wheel of a moving vehicle, are not determined by will and are, thus, not acts. Unlawfulness. Not all acts, including omissions, that are harmful to others are delicts. Before an act can be deemed to constitute a delict, it must also, in addition to meeting the other requirements, be unlawful. An act is unlawful when it infringes the rights of another, for example, when somebody is defamed or assaulted. An act is also unlawful if the wrongdoer owed the person prejudiced a duty to take care and this duty is breached, for example in the case of a policeman or woman who fails to prevent a criminal act against another. Grounds of justification are special circumstances which convert an otherwise unlawful act into a lawful act. An act which at first glance infringes the right of another proves, on closer scrutiny, to be lawful when the defendant can rely on some particular circumstance which justifies his or her act. If, for instance, a person sinks a borehole on his or her property and, as a result of this, a neighbor's water supply dries up, it would seem that the neighbor's right of ownership has been infringed. However, since such a person has exercised his or her own right, the act is not unlawful. The grounds of justification usually mentioned are by no means fixed in number, but merely represent the most pertinent circumstances generally found to give rise to the question whether the infringement alleged by the plaintiff can be justified by the defendant's claim that the act was not unlawful because he or she in fact had the right to perform the act. The following grounds of justification are usually distinguished. Necessity. Necessity exists when, through external forces, a person is placed in such a position that the person's, or another's, legitimate interests can only be protected through a reasonable infringement of the rights of another. For example, if Gert damages Kuza's house, for example, by breaking a window, to enable Mary to escape because the house is on fire, Kuza's right of ownership is not infringed, since a state of necessity justifies the performance of the act which harms Kuza's interests. The municipality which refuses to deliver meat to the public at the abattoir does not act unlawfully if the consumption of the meat constitutes a danger to public health. If a ship can be saved in a storm only by casting the cargo overboard, the owner of the cargo has no action for damages against the crew responsible for such an act. The purpose of an act of necessity is to protect the interests of the perpetrator or of a third party in a dangerous situation. Self-defense. Self-defense exists when a person, in a reasonable way, defends him or herself against an actual, or imminent, unlawful attack by another, to defend his or her own or another's legally acknowledged right. It differs from necessity in that it is a defense against an unlawful threat or attack. From this it follows that it must be an act directed against a human act, for only a human can act unlawfully. For example, if Peter attacks John with a knife, and John in turn wounds Peter fatally, then John may rely on the defense of self-defense. There are, however, several requirements that must be met in order to succeed with self-defense as a valid defense. Consent. Where a person legally capable of expressing his or her will gives consent to injury or harm, the causing of such harm will be lawful. Consent takes two forms: consent to injury, and consent to or acceptance of the risk of injury. In the case of consent to injury, the injured party consents to specific harm. For example, MPO consents that Chris, a surgeon, may remove his appendix. In the case of consent to the risk of injury, the injured person consents to the risk of harm caused by the other's conduct. For example, MPO consents to the risk that the operation performed on him, by Chris, may have certain side effects. A participant in sport consents to the risk involved in such a sport. A boxer therefore accepts the risk that a blow from his opponent may paralyze him. Consent may be given either expressly or tacitly. However, not every factual consent to injury is valid, since the consent must not be contrary to good morals. Permission given to someone to chop off a person's arm, for example, conflicts with good morals. Consent which is not given freely is also invalid. For instance, Ruth threatens to discharge her employee Sophie from her service if Sophie does not consent to Ruth's giving Sophie a hiding. Furthermore, consent given without the consenting parties being aware of the nature and seriousness of possible consequences is also invalid. For example, if Ida agrees to undergo X-ray treatment without knowing that unsuccessful treatment may possibly lead to the amputation of the limbs treated, her consent is invalid and her doctor is liable for damages. Statutory authority. A person does not act unlawfully if he or she performs an act which would otherwise have been unlawful, while exercising a statutory authority. Two requirements apply. Firstly, the statute must authorize the infringement of the particular right concerned, and secondly, the conduct must not exceed the bounds of authority conferred by the statute. For example, a municipality will not be liable for burning a fire belt over another's property where such burning takes place in terms of a statute. However, should the fire get out of control due to the negligence of the municipality's employees, and the fire destroys another's house, the municipality will be liable. V. Provocation. Provocation exists when a person is provoked or incited by another's words or actions to cause harm to the other. As a general rule, provocation is not a complete defense when verbal provocation has been followed by physical assault. However, defamatory or insulting allegations made during an argument in retaliation to provocative verbal conduct may be justified, and, if provocation takes the form of a physical assault, it may, in fact, constitute a complete defense against an action on the basis of the subsequent retaliatory physical assault. Two requirements must be met. Firstly, the provocative conduct itself must be of such a nature that a reaction thereto is reasonable and therefore excusable. Whether this is the case is judged objectively in view of all the surrounding circumstances. Secondly, the conduct of the provoked person must constitute an immediate and reasonable retaliation against the body of the other person. The action of revenge therefore must not only follow the provocation directly, but must be objectively reasonable as well. Here, reasonable means that the physical assault by the second person is not out of proportion in its nature and degree to the assault by the first aggressor. Examples of the above principles are the following: Paulina insults Wanda and Wanda returns the insult. Also, Lethabo assaults Sifo, whereupon Sifo assaults Lethabo. Wanda and Sifo can rely on the defense of provocation. However, should Wanda have slapped Paulina, or Sifo have waited for 2 weeks and only then assaulted Lethabo, they could not have claimed that they had been provoked. C. Fault. An unlawful act does not necessarily entail liability for the wrongdoer. The wrongdoer must also be at fault. A wrongdoer is at fault if he or she has acted intentionally or negligently. A legal requirement for intent or negligence is that the wrongdoer must have reached a sufficient level of mental development to be able to comprehend the nature and consequences of his or her action. One cannot blame someone who does not have sufficient mental capacity to know any better. This basic principle of the law regarding delicts is contained in the requirement that the wrongdoer must have the capacity to have a blameworthy state of mind. The law lays down, for example, that insane persons and children under the age of 7 are not capable of having a blameworthy state of mind, because their mental capacity is too undeveloped. These persons can therefore never be at fault and can consequently never be liable. Whether all children over the age of 7 years always have sufficient mental capacity is uncertain, and therefore the law provides that boys under the age of 14 years and girls under the age of 12 years shall be presumed to be incapable of having a blameworthy state of mind. This means in practice that the plaintiff always has to prove that such a child was indeed capable of having a blameworthy state of mind. Once it has been established that the wrongdoer was capable of having a blameworthy state of mind, the question is asked whether he or she acted intentionally or negligently. A person acts with intent if a person's will is directed towards bringing about a particular result and a person is at the same time aware of the unlawfulness of the actions, actual intention. If a person's will is directed towards bringing about a certain event, but it is foreseen that there is a possibility that another event may come about and, regardless of this foreseeable possibility, the person proceeds to act, he or she has legal intention in relation to the other event, also known as dolus eventualis. If David shoots a horse under the erroneous impression that it belongs to him, legally speaking, he does not act with intent, because by reason of his mistake, he believes that he is acting lawfully. In the absence of intention, a person's conduct may still be reprehensible and consequently he or she may still be at fault. This would be the case where a person's behavior does not comply with the standard of care that the law requires. In such a case, there is negligence. The criterion the law uses today to establish whether a person has acted negligently is the criterion of the ordinary or reasonable man or woman. A wrongdoer is therefore negligent if the reasonable person, had he or she found him or herself in precisely the same position as the wrongdoer, would have foreseen harm to another with such a degree of probability that, in the light of the circumstances, he or she would either have refrained from the act or would have carried out the act in another way, or would have taken further precautions before acting. If a wrongdoer has unlawfully and negligently caused damage, but the injured person has also been negligent, this is referred to as contributory negligence. The damage is divided in proportion to the respective degrees of negligence shown by the parties. Apportionment of Damages Act 34 of 1956. If, for example, Manla runs into Nkaya with his car, and both were 50% negligent, Nkaya will be able to recover only 50% of his damages from Manla. If Nkaya's total damages amount to R1000, he therefore receives only R500. D. Causation. A wrongdoer can be held liable only for consequences he or she has legally caused. Causation comprises two elements, namely, factual causation and legal causation. The former is present if a factual causal link exists between the act and the damage. But a single act can give rise to an unlimited number of harmful events, and the next step is to determine which acts should in law give rise to liability for the damage in question. The latter type of causation is known as legal causation. Factual causation is determined by applying the conditio sine qua non test. In terms of this test, the act of a wrongdoer will have caused the damage if such an act is an indispensable condition for the damage to arise. Legal causation is established where there is a sufficiently close relationship between the wrongdoer's conduct and its consequence that such consequence may be imputed to the wrongdoer in view of policy considerations based on reasonableness, fairness, and justice. E. Damage or impairment of personality. To incur delictual liability, a person must have caused another either damage or impairment of his or her personality. By damage, patrimonial damage is meant. A person suffers damage if, as a result of another's act, his or her estate becomes smaller than it otherwise would have been. For example, a person's car is damaged in an accident and is worth less as a result. Thus, to determine whether a person has suffered damage as a result of a delict, the present condition of his or her estate must be compared with what it otherwise would have been. If the present condition of the estate is less favorable, a person has suffered patrimonial damage. The person's estate must then be restored to the position it was in before the delict occurred. As regards the calculation of the amount of the damages, the following should be noted. First, a person may not raise as a defense that the other's damage has, entirely or in part, been extinguished by a third party, for example by a payment in terms of a medical scheme or insurance policy. These facts are regarded as falling outside the dispute and are thus not considered in calculating the amount of damages. Secondly, a person has a duty not to allow his or her damage to accumulate. In other words, damage resulting from his or her own fault cannot be recovered. Impairment of personality, on the other hand, results when someone's personality is wrongfully infringed, that is to say, when one or more of his or her rights of personality, such as the right to reputation and the right to privacy, is infringed. Impairment of personality does not amount to patrimonial damage, and it is, by the nature of things, very difficult to assess precisely the extent of the harms suffered in cases of this kind. For this reason, the court grants compensation calculated according to what is fair and just after consideration of all the facts of the particular case. 2.2.4.4.3 Remedies. What remedies does the law grant to a person suffering damage or non-patrimonial prejudice? In the first place, a person whose rights are threatened may protect them by means of an interdict. If someone's conduct threatens another's rights, for example, such a person excavates his or her land, which threatens to cause a neighbor's land to collapse, the neighbor can apply to the court for an order, interdict, which compels the other person to discontinue his or her activities. If, for example, a person has good grounds for believing that a defamatory report about him or her is going to be published in a newspaper, publication can be prevented by means of an interdict. If a person has already caused another harm by his or her unlawful and culpable conduct, a claim for compensation exists. Several possible actions are at a person's disposal. The action that should be used depends on the nature of harm suffered. If a person's estate has been damaged, he or she has suffered patrimonial damage, economic loss, or loss which can be assessed in terms of money, and a claim for compensation, based on the Actio Legis Equilii, is available. If a person has not suffered patrimonial damage but an injury to his or her personality, a claim based on the Actio Injuriarum, or the action for pain and suffering, may be used. The Actio Legis Equilii is thus aimed at recovering patrimonial damage, such as the monetary loss a person suffers if a wrongdoer damages his or her motor car by a delict, the Actio Injuriarum at recovering sentimental damages, solatium, such as damage to a person's good name by a defamatory assertion that he or she is a thief, and the action for pain and suffering at recovering compensation. 4. Example for emotional shock. To assert that a person is a thief can, of course, also lead to patrimonial damage. A person's customers no longer support his or her shop. In such a case, a person should institute both actions, the Actio Legis Equilii for the recovery of the damage suffered by his or her estate and the Actio Injuriarum for the recovery of sentimental damages. 2.2.4.4.4 Introduction to the Law of Unjustified Enrichment. It is patently inequitable for one person to be enriched to the detriment of another. It is therefore a principle of South African law that nobody should be enriched at the expense of another. In this context, to be unjustly enriched means that there is no valid legal ground for the person who has obtained the benefit to have done so, and that it was done at the expense of the other. If a minor child, Henry, who is not competent to enter into a contract without the assistance of his parent or guardian, buys a bicycle from a dealer, Walter, and then refuses to pay for it because he is not contractually liable, he will be enriched at the expense of Walter to the amount of the value of the bicycle. The law now gives Walter the right to claim the bicycle or its value from Henry. Thus, there is an obligation between Walter and Henry, which obligation did not arise contractually. A minor is not contractually liable in respect of transactions entered into without the assistance of his or her guardian, or in delict, the elements of delict have not been complied with. It is important to note that the claim is limited to the amount of the actual enrichment. Should the bicycle in the above example have been damaged, Walter could therefore claim only the amount with which Henry had actually been enriched, that is, the decreased value of the bicycle or the damaged bicycle itself, from him. 2.2.4.4.5 The origin of the claim for enrichment. In Roman law, the transferor of property which had been given to another person without legal title could reclaim the property from the other person by means of a legal process called the condictio in debiti. In due course, various other legal actions, condictions, were acknowledged in Roman law to provide for certain types of enrichment. These actions were accepted and adopted in Roman Dutch law, on which South African law is based. Thus, it came to be accepted in South African law that, in certain specific instances, actions could be instituted successfully against persons who had been unjustly enriched. No general enrichment action, however, is recognized in South African law. Should a claimant, therefore, wish to institute an action on the ground of unjustified enrichment, he or she will have to make use of one of the existing acknowledged enrichment actions. 2.2.4.4.6 The obligation imposed upon the enriched person. The obligation imposed upon the enriched person takes one of two forms, namely, a. restitution, or b. payment of a sum of money, compensation. A. Restitution. A person who has delivered or transferred money or property which is not due to another person may recover that money or property from the other person. Such delivery or transfer may arise in the following circumstances. I. Payment or delivery in error. A person who has paid a sum of money, or delivered property, to another person in the mistaken belief that it was due is entitled to recover the property or money from such other person, provided that payment or delivery was made under a mistake. The mistake was reasonable. Payment or delivery was not made on condition that it would not be recoverable. D. Payment or delivery was not made by way of a compromise. The action which is instituted in this instance is known as the condictio in debiti. 2. Payment or delivery under a contract which is invalid owing to illegality. A party to an illegal contract who has delivered property or money to another party may recover what has been delivered, provided such a person is not equally guilty with the person from whom such property or money is being claimed. If a person is equally guilty with that other person, the par delictum rule will prevent recovery. The par delictum rule is discussed under section B below. B. Compensation. An obligation to compensate the person at the expense of whom one has been unjustly enriched can arise in the following circumstances. Partial performance. If one party to a contract has performed only a portion of an obligation which is indivisible, for example, Anna has concluded a contract with Bob the builder to build a house for a fixed amount and the building is abandoned at roof height, whereafter Anna cancels the contract because of breach of contract by Bob, the possibility of enrichment liability arises, because the already delivered portion of Bob's performance cannot be returned as a result of its nature. Bob will, therefore, be entitled to claim the amount by which Anna's estate has been enlarged as a result of the presence of the construction on her ground, or the expenses incurred by Bob, whichever is the lesser amount. Improvements to property. If a person effects improvements to property with the intention of doing so for his or her own benefit and he or she has no right or title to the property, the improvements become the property of the true owner. The person who has effected the improvements is then entitled to claim the amount by which the value of the property has been increased from the true owner. This amount represents the amount to which the true owner has been unjustly enriched at the expense of the person who effected the improvements. Thus, if a person mistakenly believes that he or she is the owner of ground and erects a house on it, the value of the house may be claimed from the true owner. The measure of compensation claimable in such an instance depends on the nature of the particular improvement to the property, but may not exceed the actual expenses incurred in connection with it. The amount recoverable is thus the lesser of either the defendant's enrichment or the claimant's impoverishment. Should the true owner not wish to accept the improvement, it must be removed by the person who effected it, provided that the removal will not damage the property. 3. Negotiorum gestio. Negotiorum gestio is related to enrichment. It arises when one person voluntarily, and without the permission or knowledge of another person, manages the affairs of the last mentioned. For example, if Lala has Brenda's property stored after a tornado has blown away the roof of Brenda's house in her absence. If the person whose affairs have been managed accepts the negotiorum gestio, he or she is obliged to compensate the person who managed them for all necessary expenses incurred. Further reading. W. J. Hostin, A. B. Edwards, F. Bosman and J. Church. Introduction to South African Law and Legal Theory 2 ed. 1998, Section B.